Hi, this week we're going to be discussing chapters 18 and 19 in our business law book. Chapter 18 is about the law of administrative agencies. The first two federal administrative agencies were the Interstate Commerce, which is no longer in existence, and the Federal Trade Commission. Administrative law is any rule, statute, or regulation that directly or indirectly affects an administrative agency. These rules may be procedural or substantive, and they may come from the legislative, executive, or judicial branch of government or the agencies themselves. A procedural rule is a rule that governs the internal processes of an administrative agency. A substantiative rule is a rule that creates, defines, or regulates the legal rights of administrative agencies and the parties they regulate. Administrative agency is any body that is created by the legislative branch to carry out specific duties. Independent administrative agencies are agencies whose appointed heads and members serve for a fixed term and cannot be removed by the president except for the reasons defined by Congress. An executive administrative agency are generally located within the department of the executive branch of government. An example would be the Occupational Safety and Health Administration, and this is located in the Department of Labor. Enabling legislation is legislation that grants lawful power to an administrative agency to issue rules to investigate potential violations of rules or statutes and adjudicate disputes. Legislative power is the power delegated by Congress to an administrative agency to make rules that must be adhered to by individuals and businesses regulated by the agency. These rules have the force of law. Executive power is the power delegated by Congress to an administrative agency to investigate whether the rules enacted by the agency have been properly followed by businesses and individuals. Judicial power is the power delegated by Congress to an administrative proceeding, which includes the power to issue a complaint, have a hearing held by an administrative law judge, and issue either an initial decision or the heads of an agency. Administrative Procedure Act is a law that establishes the standards and procedures that federal administrative agencies must follow in their rulemaking and adjudicative functions. There are three major rule-making models, the first one being formal, the second one being informal, and the third one being hybrid, and that is outlined in the Administrative Procedure Act of 1946. Consent order is an agreement by a business to stop an activity that an administrative agency alleges to be unlawful and to accept the remedy the agency imposes. No admission of guilt is necessary. Administrative law judge is a judge selected on the basis of a merit exam who is assigned to a specific administrative agency. Preponderance of the evidence is a legal standard whereby a bare majority, 51%, of the evidence is sufficient to justify a ruling. The APA requires that the Commission state factual, legal, and policy basis for its decision. The power of the administrative agencies is limited by executive branch through 1. The power of the President to appoint the heads of agencies, 2. The power of the Office of Management and Budget, which is also called the OMB, to recommend a fiscal year budget for each agency, and number 3, a presidential executive order. That was Chapter 18. Now, Chapter 19 deals with employment relationship and immigration laws. There are laws that employers must follow regarding wages and hours an employee can work. One of the most significant aspects of the Fair Labor Standard Act is that it requires that a minimum wage of a specific amount be paid to all employees in covered industries. The FSLA also requires that employees who work more than 40 hours a week be paid no less than 1 1/2 times their regular wage for all of the hours beyond the standard 40-hour work week. In 1935, Congress passed the Federal Unemployment Tax Act, which created a state system that provides unemployment compensation to qualified employees who lose their jobs. Workers' compensation laws provide financial compensation to employees or their dependents when the covered employee of the covered employer is injured on the job On August 5th, 1993, the FMLA Act, or the Family Medical Leave Act, also known as FMLA, went into effect. And this law is designed to guarantee that workers facing a medical catastrophe or certain specified family responsibilities will be able to take needed time off from work without pay, but without losing medical benefits or their jobs. In 1970, the Occupational Safety and Health Act was formed to make sure that every employer is to furnish to each of his employees free from recognized hazards that are likely to cause death or serious physical harm. The Occupational Safety and Health Review Commission reviews OSHA citations, and they issue penalties and abatement periods when they are contested by an employer. The National Institute for Occupational Health was established under the OSH Act to identify occupational health and safety problems, to develop controls to prevent occupational accidents and diseases, and to disseminate its findings, particularly to OSHA. So that is my reviews summary of chapters 18 and 19 this week. I guess I will see you next week. Thank you very much.